Welcome to Employment Law This Week. I'm George Whipple. Our top story, California passes the first statewide $15 minimum wage. Last Monday, Governor Jerry Brown signed a bill that will raise California's minimum wage to $15 an hour by 2022 for companies with more than 25 employees. The increase will begin next year, moving from $10 an hour to $10.50 an hour. California, one of the world's biggest economies, is the first U.S. state to commit to a $15 minimum wage. And the trend is continuing, with similar legislation signed in New York last week. David Jacobs has more.
The $15 an hour wage trend may continue beyond California and New York, but not on a statewide basis. We may see certain cities or regions within states go to that level, but certainly nothing nationwide. Employers in California will need to review their current employee ranks in terms of exempt, commissioned, and creative professional employees to make sure that as the minimum wage increases, those employees remain properly classified.
The SEC backs in-house counsel's whistleblower status. A tax attorney filed a wrongful termination suit against Vanguard for firing him after he raised questions internally about the company's tax practices. Vanguard moved to dismiss the complaint, in part because the former employee only reported the alleged wrongdoing to the SEC after he was terminated. In some courts, this would disqualify him from whistleblower protections. But in an amicus brief, the SEC backed a broader interpretation of Dodd-Frank, confirming its view that internal whistleblowing to a supervisor or a compliance officer constitutes protected activity. This interpretation is aligned with the Second Circuit's view, but the issue may ultimately be settled in the Supreme Court. The Department of the Treasury puts non-competes under the microscope. A recent report from the U.S. Treasury calls for more transparency in non-compete agreements and better communication around their use. Around 18% of the workforce is subject to these restrictive covenants, and scrutiny around them is increasing on both the state and federal level. A recent Utah statute restricts non-competes to no more than 1 year, while Oregon and Alabama recently tightened their statutory restrictions. The NLRB continues to take an expansive view of protected activity for a non-union employee. A former mortgage banker for Quicken Loans in Arizona was overheard using foul language to discuss a client in the office bathroom. The banker was fired after denying knowledge of the conversation. He filed a charge with the NLRB, arguing that he had engaged in actions protected under the National Labor Relations Act. An administrative law judge imposed an adverse inference against the company because the other employee in the conversation did not testify. The judge then found multiple violations of the Act, citing the termination, the company's overbroad separation documents, and more. Like the Jimmy John's negative publicity case we reported on last week, this ruling embraces a broad view of what constitutes protected activity under the NLRA. Now it's time for our tip of the week. Zan Raskin is the president of Artisan Consulting and also part of EBG Advisors. She's here this week with some advice on best practices for workplace investigations.
The two best practice tips I have on conducting investigations actually occur way before you even speak to anybody. So the first one is making sure you select the right investigator. That's really critical. You want someone who's both perceived and is objective, someone who can be unbiased and independent in terms of looking into the issues. I always recommend drafting a preamble. That's a written statement that you read to anybody that you're interviewing, both the complainant, eyewitnesses, anybody who's involved in the investigation that you need to speak with. In that respect, you can make sure that you set expectations around confidentiality if that's appropriate, that you talk to them about the fact that the company doesn't tolerate retaliation, and that involves giving them sometimes some examples of what retaliatory behavior could look like, and giving them contact information, whether it's the investigator or somebody else at the company, to call or contact if they think that there's anything else that happens that they need to talk about.
Thanks, Ann. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.